children because they're vulnerable. Court is calling 2023 CR 6579, State of Texas versus Jordan Summers. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Lynn Payne for defense.
And are you Ms. Summers?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Summers, did you review and sign a document entitled Application for Community Supervision with your attorney?
Yes,
Did you
ma'am.
understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count one, proceeding on count two with this enhancement.
And you going on the enhancement?
Yes.
Okay.
Yes, Your Honor, sorry.
Oh, no problem. Any objection to the waivers?
No, Your Honor.
Ms. Summers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
And count one, you're charged with the offense of possession of controlled substance penalty group 1 gram to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the state is able to prove up the enhancement, your range of punishment will be 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
in my opinion, yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes.
Ms. Summers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Of the record? All right, y'all need to move to this end. If you want to talk to your client, you need to move to this end. All right, Ms. Summers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count 2. You agree that you've been previously convicted of a felony for purposes of enhancement.
Yes, ma'am.
Punishments be assessed at 10 years in the prison. There's a $1,500 fine. State recommends community supervision. They're taking in consideration NIMAG number 6827297374778. There's to be restitution to Live Oak for drug testing and to complainants and NIMAG numbers 6827297374778. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state.
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 250 hours community service restitution, no contact with the complainants, and NIMAG number 6827229 and 7874778. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the enhancement paragraph, which reads, and it is further presented in and to said court that before the commission of the offense alleged above on March 6, 2020, and cause number 2015 CR 11078 in Bexar County, Texas, the defendant was convicted of the felony of possession of a controlled substance, penalty group 1 gram to 4 grams. How do you plead? True or not true?
True.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all those attachments.
Any objection?
No objection, Your Honor.
You may continue to confer.
Thank you.
Going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, and also the court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Is there anything you wish to say on behalf of your client?
Your Honor, I've spoken to my client. She's currently, has got a job. She's in my opinion, the right frame of mind to complete this probation successfully, given the tools. She understands that she needs some tools and a little bit of help. And we're just going to, of course, grant her the probation, as we agreed to.
All right, who is Cody Ring?
That is an old friend from a few years ago. I don't
All right.
associate with them.
And where do you work? I mean, well, what do you do?
I'm a PCA at Northeast Baptist Hospital.
What do you do there?
I'm a patient care associate, so I take vitals and pretty much clean up after the patients. Specialize in nursing, and it's in the emergency room, so it's a progressive care unit is where I'm located, so.
All right, if you're drug tested today and know you're going to be drug tested today, what are the results going to be?
So probably dirty,
Dirty for what?
nothing.
All right, so I'm going to tell you what I have a problem with. And I think you already know.
We did discuss the possibility.
All right, because people who are using drugs really shouldn't be caring for vulnerable people. And I guarantee you, anybody who loves their relative, if they knew you were using meth, they would not want you taking care of them, be it drawing blood or anything of that nature. So she can't work there. She needs to get a job. I mean, is she telling that company, hey, I'm currently using drugs?
Of course not, Judge, but would the court consider doing zero tolerance drug test now? I mean, she's been working there 3 months and they've kept her on, and she does have a history. So they hired her and it is a very decent job.
But do they know that she's currently using drugs? Because the problem is, if she's using drugs and there are patients there that need drugs, then she could potentially end up taking their drugs. I'm not saying that that's what's happening, but people need to stop hiring people to be home healthcare providers, draw people's blood and do all of this when they have all of these things in their past and they're still doing the same thing. So her history, obviously she's a repeater, which means she's been to prison for drugs. And now she's coming out and she's picking up another drug case and she's currently using drugs. Did you just come from work?
No, ma'am, I'm going to work, but not anymore.
So,
And we did discuss the possibility before.
all right. Do you have any children?
No, ma'am,
All right. Who do you live with?
my aunt.
Okay. I mean, and once she becomes clean and sober, the court will reconsider things. But I'm sure maybe that company needed somebody and they were taking a chance on her. But my role, I feel like my role, part of it is protecting the community. And I can't, in good conscience, have you being in the position that you're in with vulnerable people and you're using. You understand? So when's the last time you used meth?
Like this weekend, the one that just passed, probably Saturday.
All right, it'll be more than Saturday if it's still in your system. Other than meth, are you using anything else?
Amen.
Okay.
So-
All right. Yes.
Pardon, just so would you consider allowing her to go and speak to her employee? Maybe take a week off or have a drug test? Maybe they'll give her a week off to continue the position.
I mean,
And
I
you
can't,
can routinely
I can't trust that. I mean, if they want to come in and say, we know that she's using meth, we know A, B, and C, I'll consider it, but I'm not inclined to grant it because somebody has to protect the vulnerable people in society. So, I mean, you can't use meth and take care of people. You can't use meth and take care of elderly people because they're vulnerable. You can't use meth and take care of children because they're vulnerable. All right, so this is what the court is going to do. Court is going to sentence you to 10 years in prison, suspended and probated for 10 years. And if you start doing well on probation, I can always consider different things, but wherever you work, they need to be given a heads up and given a true rendition of where you are in your life. You understand? So there's going to be a $1,500 fine that will be probated. Proof of employment within 30 days, and your client was late for court today. There's to be no employment as a home health care provider or with minors. Take in consideration NIMAC number 6827229, 737478. There's to be restitution, if any, to Live Oak for drug testing. If you feel like they're asking for too much for that, we can have a hearing on it. And restitution, if any, and cause numbers, NIMAC number 6827229, 737478. We can do a TAP eval while out of custody. Whatever the TAP evaluation recommends, we're going to start with intensive outpatient treatment. And we can do a referral to felony drug court. They have a wait list, but maybe they're going to do a graduation soon. There is to be no contact with Cody King and the complainants, and NIMAC numbers 6827229, 737478. There's to be 250 hours of community service restitution. The court will not waive those hours. You need to do those hours. Field visits, 1 time per month until she's in treatment. And then thereafter, it'll be at probation's discretion. There's to be regular random UAs. And I'm going to want 90 sober meetings in 90 days. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Summers, I'm not trying to be cruel or mean to you by saying you can't work in that field. But if you think about it honestly, if you had your aunt or some relative that you loved, you wouldn't want somebody who's using to be taking care of them, right? All right, good luck to you.
Thank you.
And this is no application.
No application.
All right, court is going to call 2023 CR 7127, State of Texas versus Richard Rodriguez Jr. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Denny Callahan.
Are you Mr. Rodriguez? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1 and the second enhancement paragraph. We're proceeding on count 2 with repeater, which would be the first enhancement, Your Honor.
Any objection?
No objection.
Mr. Rodriguez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney?
Yes,
Did you
Your Honor.
understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on on count 2 with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? Normally, that's a second-degree felony, and that range of punishment will be anywhere from 2 to 20 years and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If the state is able to prove up the repeat offender enhancement allegation, then your range of punishment will be that of a first-degree felony, and the range will be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Rodriguez, has anyone coerced you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2. You are to agree that you've previously been convicted of a felony for purposes of enhancement. Punishment is to be assessed at 10 years in the prison. There's a $2,500 fine. There's no application for community supervision. State, this UUMV, is that 2023?
Yes, Your Honor. If you, I can correct it on it.
Yes, if you're just writing it. Oh, no problem. The state will take in consideration 2023 CR 7127, 2023 CR 72,
Yeah, Your Honor.
yes,
Let me put that back in.
okay,
I apologize.
no problem. Oh, yeah, the 7127. All right, so the record is clear. 2023 CR 7127 is not the case that's being taken in consideration. That's the case that you're pleading to. Do you understand?
Yes, Your Honor.
All right, thank you. No problem.
That was correct.
All right, so the state will be taking in consideration 2023 CR 7289, 2023 CR 7290, and 709582. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, there have been such motions?
No, Your Honor.
Then to the offense as listed in count 2, how do you plead? True, or I'm sorry, how do you plead? Guilty, not guilty, or no contest?
No concept.
And to the enhancement repeater paragraph, which states, and it is further presented in and to said court that before the commission of the offense alleged above, hereinafter styled the primary offense on the 22nd day of May AD 2007 and cause number 2006 CR 5571 In Bear County, Texas, the defendant was convicted of the felony of possession of a controlled substance. Penalty group 1 gram to 4 grams. How do you plead? True or not true?
True,
I'm sorry?
true,
State any evidence to support the defendant's plea.
Yes, Your Honor. State exhibit number 1 with all of its attachments.
No objection.
All right, you may continue to confront. Mr. Rodriguez, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I ask the court respectfully to follow the plea agreement.
All right, the court will follow your agreement, sentence you to 10 years in the prison, give you credit for any time served. There's a $2,500 fine. Time and money will run concurrent. Take in consideration 2023 CR 7289, 2023 CR 7290, and 709,582. And of course, as I've already stated, I found the enhancement paragraph true. Is there anything else with regards to sentencing?
No, Your Honor.
Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. If you would like, I can have you referred to the therapeutic community. I have no control over it. But if you have a drug or alcohol issue, they may be able to help you with that. Would you like that?
No, Your Honor.
No,
Okay.
Your Honor.
All right. That's fine. All right. We can go off the record. How old are you?
47.
47. All right. You're going to have to make some choices in your life. I know that 10 years is a long time, or even 1 year or 1 day is a long time,
Yes, ma'am.
but you need to sit and think about how you got to where you are and whether or not you want to continue to be where you are.
No, ma'am.
All right. Good luck. All right. Good luck to
Yeah, all
you.
right. Thank you.
All right. You're welcome.
Thank you, Judge.
Court is calling 2019 CR 9679W, State of Texas versus Ben Camarino. That party is announced for the record for the state.
Casey Garrett, Your Honor.
Defense,
Lorraine Ephraim?
are you Ben Camarino?
Yes, ma'am.
Going to show you what's entitled motion to enter adjudication of guilt and first amended motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ben Camarino who was placed on deferred adjudication in 2019 CR 9679W for the offense of aggravated assault with a deadly weapon on September 23rd, 2019 for a period of 10 years? Is that you?
Yes, Your Honor.
State?
Yes, Your Honor. Violated condition number 1 on or about the second day of November 2022 in Bear County, Texas. The defendant, Ben Camarino, committed the offense of possession with intent to deliver controlled substance in violation condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and that is to adjudicate guilt, revoke the individual office probation, sentence him to 7 years in Texas Department of Corrections. And the state will take in consideration cause number 2023 CR 6258, which he has pled truth.
All right. Defense, is that the agreement?
Yes, Your Honor.
Mr. Camerino, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement, find you guilty, sentence you to 7 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. Taking consideration 2023 CR 6258. There's an affirmative finding of family violence. There's to be no contact with Michelle, Michelle, Lubow, Lubow. And there's a $1,500 fine, time, and money to run concurrent.
And may I address the court on the
Yes.
back time, Judge?
Yes,
So he was a fugitive on this case since, let me make sure I've got this right. The warrant was issued on this MTR December 2nd, 2022. He was arrested and booked in Kerr County on December 21, 22. So we are asking that for the period of time he was in Kerr County and the warrant was outstanding here from December 21, 2022 through October 2nd, 2023, that he be given that time. He was, in other words, he was booked into Bear County, I think on October 3rd, 23.
Mhm.
So he was in Kerr County from 12/21, 2022 through October 2nd, 2023.
I'll give him credit for any time that he was in custody in another county, as long as that credit is associated when this warrant was issued for a motion to revoke.
Okay,
So if the motion to revoke, and I believe what the court reporter has written, the motion to revoke was December 2nd, 2022, that's when it was issued. So if something happened before December 1st, he's not going to get credit for December 1st because no warrant was issued on this case. But from the time a warrant was issued on this case, if he was in custody in another county, then he will get credit for that.
okay, so just for purposes of the judgment, do you want me to give something to the clerk?
Yes.
Okay, does the court want to make note of the Kerr County case numbers to run them concurrent? That might also.
Yes.
Okay, the Kerr County case numbers are B23.
Just 1 second.
Okay,
Yes, I'm ready.
B2383, B2384, and B2385.
And that's B as in boy.
Yes, Your Honor, as in Boyd. And
All right.
I'll be here tomorrow. I'll bring something to the clerk.
All right, so this case is to run concurrent with Kerr County cases, cause numbers B2383, B2384, and B2385. Is there anything else with regards to sentencing?
No, Your Honor. Well, he also has time in safety. I guess I should mention that too.
Was it successfully completed?
Um,
Probation, did he successfully complete safety?
Yes, Your Honor, twice.
Well, is it really a success if it's done twice?
You know, there was a lapse in time before he was sent back.
All right, I'll give you credit for time served in safety.
it's more than fair to say he has struggled.
All right, I'll give you credit for any inpatient treatment time. And if you would like, I can refer you to the therapeutic community. It will be up to them whether or not they accept you. Therapeutic community doesn't increase the time you're at the prison. Would you like that?
Yes.
All right. So I'll request therapeutic community, but you're going to have to ask for it as well. Okay.
Okay.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement. Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. If you don't stop what you're doing, you're gonna find yourself living your life at the prison. If you don't want to be at the prison, if you don't want to become institutionalized, you're gonna have to make better choices. If you have a drug or alcohol problem, there are so many free places now for people to get help, but you gotta want it. And you gotta use the tools that are given to you once you're out of inpatient treatment. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge.
You're welcome. Joshua Patillo. Oh, Miss Compton. All right, where's Patillo?
He's over here.
All right, so with regards to these cases, there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
Yes, Judge. So a couple of things I would like to ask the court about. So first of all, Mr. and I think he pronounces the same Patillo, but I'm not sure. So, Mr. Patillo recently returned from the state hospital. He was found to be restored. However, he is not receiving the medications in the jail that he was receiving at the hospital, and
Okay.
he's starting to have some.
So is he receiving, are you receiving any medications at the jail?
Yes, ma'am. But it's not it's not the same medication that the doctor gave me.
All right, any objection to me calling to see about this?
I have no issue with that, Judge, and I would like, if, I don't know how the courts do here and there, but sometimes the courts can order that he be given the medications that he was coming from the hospital with.
All right, just give me one moment.
Sure.
Could you mute us, please? All right, so what we'll do is I am going to text the sheriff his case number and SID number
Okay.
and put in a text message that it's about his medication, so he'll remember it. And then if you know your medications that you have from the state hospital, if you will give that to your attorney now, and then you, me, and the state, we can type it up right now and I'll email it right now before this hearing is done.
Okay, that sounds good. The other thing is, I was, of course, waiting for him to be back before I requested a sanity evaluation. And, but if he's having issues, I definitely want to make sure that he's stabilized and okay to undergo that. But it's been so long ago that I will have to double check. Usually when I file the request, I file for both competency.
Yeah, and they always, yeah.
But I think probably the safest thing would be for me to file separately, or if I can just make an oral motion to the court this morning.
All right, so do you still want the sanity eval?
Yes, Your Honor, I do.
All right, do you mind if I just email the court and let them know that there's going to be a sanity evaluation request?
I think that would expedite things greatly.
Okay, even though we say expedite, it's still going to take a while.
I understand.
So let me put that in here. It's 8-1.
And Judge, if I could also just request if I could email and you can give me whatever email you want me to send it to, but I would feel a lot more comfortable checking the paperwork I have with regard to the medications
Okay,
rather than have someone just self-report the medications that
Okay.
they're taking, because I sure wouldn't want to get it wrong and have something ordered for him.
everyone, please whisper.
I wouldn't want to have anybody ordering anything for him that he actually wasn't taking or something had changed. So I think I definitely want to have his doctors from the state hospital involved in at least confirming whatever medications he was on
Okay,
before that's ordered for him. But I will follow up on that because that's very important for him.
all right, and I've just sent the email to Judge Carruthers Court and to the coordinator there, asking the sanity evaluation.
Right. And then I guess if there's an email or anybody that you want me to contact,
Mhm.
and I can certainly loop you in as well as the prosecutor on any of the,
All right, if you could, once we finish here, if you could make sure you go down to Judge Carrera's court to make sure that email didn't get lost.
yes, ma'am, I certainly will.
All right, and then if you will give me your email,
Sure.
and what I'll do is I'll send an email to to the sheriff now to let him know that you will be emailing him. Here we are. To let him know that you will be emailing him an update on your client and what medications your client is supposed to be taking. Norma, on Pitio, can you put him on the same date as her other client, the 9th? I know this is not going to trial on the 9th, but we'll just put it on the 9th, so you'll be here for that as well.
That sounds great, Judge. Thank
Okay.
you. And then, would you like me to include the court on the correspondence to the sheriff's office?
If you wish to, you
It might
can.
get their attention more. than
Sure.
If it was just coming from me.
All right, no problem. So is there anything else?
No, Your Honor, that's it for now.
Any discovery issues?
He has multiple cases. So my answer to that at this point is I'm not sure.
All right, so what we'll do is we'll bring it back on the 9th, and that will be your discovery date, plus to see about the medication issues.
Thank you, Judge.
And if there's something that happens while you're on break and you want to email me, because my email will be included in this, just include the state in your email if there's an issue with the medications.
Absolutely.
All right.
Thank
Is
you
there-
so much.
You're welcome. Is there anything else?
That's it.
All right, anything else you need?
Oh, no, man.
Yeah.
All right, thank you.
Thank you.
You're welcome. Norma, on Sebastian Delgado, I'm gonna need a date for PTD. All right, so we're gonna come back on January 8th on your case. Between now and then, let me just tell you what you probably need to do, because I think if I were to drug test you today, you're probably gonna be positive for marijuana. You understand? So you need to stop hanging around people who are not bringing goodness into your life. I know a lot of young people think, it's just marijuana or it's just this, where you're on a track in your life, you're 18, you still have more of your life in front of you than behind you. You're getting this chance to do a pretrial diversion. So stop smoking marijuana. You understand? Stop hanging out with the person that you were with when this happened. Just go to work and go home. That's it. Are you still living with your parents?
Yes, Your Honor.
All right, so go to work and go home. That's it. If you do that, you won't get into any trouble. All right, we're going to go back on the record in 2023 CR 9521, State of Texas versus Sebastian Delgado. My understanding is defense, you're asking that the plea be withdrawn.
That is correct, Judge.
Any objection?
No, Your Honor.
All right, so the court will allow the withdrawal of the plea. We're going to come back on January 8th to see where we stand with PTD. State, if you want to get with the clerk to see about removing the stips, or if y'all can print them out again, however you want to do
We
that.
can always print them out again, so
Okay.
there's no need.
All right,
Thank you, Judge.
you're welcome.